I'll call the Pownell DRB meeting to order, August 3rd, 7 PM. We have approval of the agenda. Continued hearing permit application for John Babson for business on the property. Zoning administrator would like to speak. The board will have a discussion. We will listen to public comment. We will formulate our decision and we will adjourn. Motion?
I make that motion.
I'll second.
All those in favor, roll call.
Roll call. Carl Strohmeyer, aye.
John Bashy, aye.
Cindy Legg, aye.
Olden Dwyer, aye. Cody Gardner, aye. Jim Winchester, aye.
Matt Gardner, aye. Zoning administrator.
I thought that's after your public hearing continuance.
No? Well, this is part of it, so
Oh, okay.
This is it.
just before our board discussion.
Perfect. Put me under the gun already.
Yep.
I'd like to clear a few things up that have been stated and in my opinion have been misstated about this whole process. And how the DRB operates, how the zoning operates, in my opinion. A permit application came before the zoning administrator, me. I looked at the permit. I denied the permit. I gave the applicant his options, which one of them is to the way our bylaws are written and the way things operate. One of his options was to bring the permit in front of the Development Review Board. At that point, the zoning administrator is basically done. Whatever the Development Review Board comes up with for a decision, I'm bound by that decision. In this particular case, this applicant did everything that was asked of him, brought the application to me. Matter of fact, I think I sent it back once because I thought it was incomplete. Completed it. I denied it. He legally, within his legal rights, for sure, exercised his option to bring it before the Development Review Board. And at that point, it becomes the Development Review Board's decision. And that's basically what happened in this whole process. So some of the misstatements that are out there about how this happened, I just wanted to clear those up because this is how it happened and this is the legal process to make this move forward. Thank you.
Thank you. Board discussion. After our site visit, the feelings from the board, any relevancy to the permit from any of the members of the board after our site visit?
I was not impressed when I first went there on our first site visit. I thought it was a mess. I thought it was just too much. Just my opinion, just too much going on, a small amount of space. And I have to say the second time I went back there, just in my opinion there again, I thought it looked much better, more organized. He did get rid of a lot of things that were eyesores. He did put up a fence and then I guess he has ongoing plans. So it was a more positive visit for me in that aspect. Just my opinion.
Okay. Anyone else?
I don't know. You know, this is a case of being on the planning board. Sid will tell you, we make rules for you people and they have to more or less live with it. I have a very hard time with the rights of someone to destroy somebody's property. And as he says, there was a movement to do a little better. I think the first time we were there, it was muddy and there was a lot of things. You know, there was feather. Try to put up some screening, did some things. It's a gray area right now. It's people's rights. I see Paul is here, Arsh. I love Williamstown. I drive there all the time. Go to the bank, my accountant's there. There's a piece of property there by Standard Film that's been there for years, and it doesn't look very nice. With all the ordinances and all the people in power in Williamstown, I don't know how this place exists over there. And it just drives me, nothing to do with here, but people have rights and they're hard to get rid of them. And that piece of property has been there a long time. Looking at this piece of property on RR2, it's just, it blows my mind how a town like Williamstown can keep that piece of property. And it should be moved to Pownell because it looks like Pownell in some places. And that's, I guess that's all I got to say.
Any other comments from the board? Public comments from the abutters and the permit process? Any new and relevant comments from any of the abutters?
That would be, the butters would be the property people that abut his property.
Yes, the property abutters that were granted party status in this hearing.
I just want to ask how he can run that business now with no permits granted. He's running it and nothing's happening. So nothing has been granted, but he's still doing business out of there. So I don't understand that process.
That part, Jen, is where we allow the individual. It's similar to one of the last permits. He had a business. He came in for a change of use permit. You couldn't technically shut him down while he was doing the permit process.
Okay.
He was kind enough to come in, apply for the permit and carry forth with the process.
Okay.
So technically, I suppose there may be some language somewhere where you could shut it down in the term of the permitting process. It was in a way functioning prior to the application. So probably there was if there were verbiage, we probably could have. I'm sure that there's a process that we could have followed through with. May not have, probably chose not to in several instances, so.
Just wanted to understand. Yep. Thank you.
I'm not against anybody doing business out of this place. I mean, the person should be able to do.
Point of order. Jen, could you just announce your name for the people?
Jennifer Olansky.
Okay, and you're,
Arthur Lake.
okay. Are you in any other butters wish to speak? That would be Jared? Anybody who abuts the property is to speak right now, in a minute.
Oh, yeah.
My name is Andrew Lechner. I represent Deborah Eaton. So I do have some comments to make on her behalf. I have this packet for each of you members of the DRB. It's just an exhibit with some things I'm gonna discuss. Okay. You can have one too, there's a few there.
Make sure that our secretary.
Might be too long, but-
Do you want a chair?
No, but I want to talk to you.
Yeah, we have a fun.
Okay. Did you get one?
I was gonna ask the ZA if we would see the capacity. Yeah. That's fire escape.
This was from the visit when you.
So I appreciate all your time holding this tonight. This packet is various documents and pictures from the zoning bylaws, also state statute, and pictures from the site visit on Monday, and also 2 shots taken from a drone on Miss Eaton's property. So the reason we're here, as the zoning administrator pointed out, is because a permit was denied and the applicant could take it up to the DRB to review the permit application, which was for running a business on his property. If you look, I'm going to be going through this packet basically in chronological order here. On page 1, this is
Thank you.
Vermont statute 24 VSA section 4446. And it states, within the jurisdiction of any municipality that has adopted any of the bylaws authorized by this chapter, no land development may be undertaken or effected except in conformance with those bylaws. That specifically states the authority for the town and the expectation there. If you turn to the following page, 24 VSA section 4448, the highlighted portion states, the administrative officer shall administer the bylaws literally and shall not have the power to permit any land development that is not in conformance with those bylaws. That is the obligation on the zoning administrator and on the town to enforce those bylaws. If you flip to the next page, I'm sure you are familiar with this. This is from the town zoning bylaws. Section 4.11 reiterates the same point that the zoning administrator shall not permit any land development which is not in conformance with this bylaw. This is also followed by the courts in Vermont. There's a case that I didn't bring with me. I didn't want to bore you with that, but it's Sullivan versus Lakeview Inn. And the environmental court states that the zoning administrator has an absolute duty to administer and enforce the zoning bylaws. So this sets the kind of the legal precedent here with applying the bylaws as they're written in their, how they're literally written, and that's how they need to be enforced. So now if we turn,
Would you like to read the 4.12 of the Development Review Board, seeing as how that's what we're dealing with at this particular point in time?
oh, well, I'll get to that.
No,
We're-
chronological order you said, so.
Yeah, sure. This isn't really relevant. This is just how the board is established. If you want to go through it.
Consider and grant or deny requests for variances upon appeal.
Correct.
So that's where we're at with this particular, the zoning administrator has been alleviated of his duties.
Correct.
Once he denied the permit. So at this point in time, most of this is irrelevant.
Well, if you're talking about granting of a variance, then,
Then we're DRB, so can we get to DRB and not zoning?
well, the DRB, you're seeing this on appeal right now. So variance, that could be part of the discussion, and I have various arguments for why a variance is inappropriate in a separate document that I sent out to the chair. Is that you, Matt? Are you Matthew?
Didn't read it.
I emailed it, but I also have copies with me, so I can distribute those as to why variance is inappropriate. If you want to skip to that part of the conversation, we can get there. But right now, I'm just going from the ground up and explaining why.
For time constraints and everybody's purposes, can we skip to that?
We absolutely can. But first, I would like to just touch on the fact that if you're discussing a variance, that means that this proposed use doesn't fit within any permitted uses in the rural residential 2 district. Is that correct? That's correct. Okay. Bear with me one moment. Sorry. This stack, if you wouldn't mind just passing these around the table. I'll give you another line.
Was this 22
This is my first exhibit, Exhibit A, which I was going to get to second, ironically, for being Exhibit A. So this is a letter that I wrote, that I sent to the chair of the DRB today and also brought in person, which discusses the legal criteria for granting a variance and the legal precedent behind it. And I'm not gonna bore you guys with reading this whole thing unless you would like me to, but the basis is that there's 5 criteria for granting a variance, which I quoted that it follows over from page 1 to page 2. And the legal precedence that's made very clear in the environmental court and the Supreme Court of Vermont is that all 5 criteria need to be satisfied for a variance to be granted, or else the court will reverse the decision. and they're very specific criterion. And if you start with me on just the first one, it's very clear that Mr. Babson's commercial use on his property doesn't qualify even under criterion 1, let alone 2, 3, or 5. I would say 4 is up for debate, but we won't get to that here. So criterion 1, there are unique physical circumstances or conditions, including irregularity, narrowness, or shallowness of lot size or shape, yada, yada. Skip down towards the end, and not the circumstances or conditions generally created by the provisions of the bylaw in the neighborhood or district in which the property is located. And so there's a distinction here between the physical circumstances or conditions that are from the provisions of the bylaw. And the courts have discussed this further. I won't look through it now, but physical circumstances has to do with whether there's setbacks or it's a small lot and they can't build. And there is an emphasis on making reasonable use of the property. That just is not the case here, where it is simply a commercial use. There very well could be reasonable use on the property through having just, say, a one-family residence or a multi-family residence. If we go to criterion 2, it says because of these physical circumstances or conditions, there is no possibility that the property can be developed in strict conformity with the provisions of the bylaw, and that the authorization of a variance is therefore necessary to enable reasonable use of the property. Again, that's the reasonable use phrase there. That's very important here, where the courts have discussed this. All the legal precedent is in section 2. And for example, one quote from the court is that we are directed to deny a variance if any reasonable use can be made of the property which is in strict conformity with the zoning regulations. Now, if we're talking strict conformity, if you look at the rural residential 2 permitted uses, the single family residence, 2-family residence, there's plenty of permitted uses, none of which are running a commercial business as you please on your property. So under legal precedent, those reasonable uses are reason why this project would not conform to criterion 2. I don't know if you want me to continue here, but I will reiterate the fact that the courts require all 5, and they're very, very clear about that. The first paragraph of section 2 in my letter states, a quote from the court saying, if a zoning variance is to be granted, it must be based on a showing of conformance with each of the 5 statutory criteria. If just one criterion is not satisfied, the variance must be denied. That is directly from the Supreme Court. If you grant a variance and it's challenged, which it will be overturned in a court of law. So that's my discussion of the variance and whether there's authority to grant one. Of course, there are very limited circumstances where it's completely in the DRB's authority to grant a variance. A common instance is if it's a unique small lot issue where you can't even build, say, a relatively small residence in a residential area. You can't do anything with your property. In a circumstance like that, to allow a reasonable use, the DRB might allow a variance, like within the setbacks, the physical restraints of the property, or if there's too much of a slope or some physical thing that prevents any type of use of the property. But in this circumstance, that just isn't the case here. And so, on behalf of my client, we're asking that you do not grant a variance here because it is inappropriate, and we will challenge it And we feel very strongly that the court would not uphold the variance. And we ask that you follow the zoning regulation literally as it's required and enforce any type of use that doesn't conform with the permitted uses within the rural residential 2 district. If there's a duty and an obligation for you as a town to uphold the bylaws. And if Mr. Babson does not come into conformance, it's within our right to request an enforcement action to make it on the record that he is in violation of the zoning bylaws. And if you as a town do not follow through with the enforcement action, we can seek the court to intervene and issue what's called a writ of mandamus, which is an order compelling you to follow the zoning bylaws.
Witness Slate Ridge.
No, we're not talking about any other project, anything else in town. All we're talking about is this zoning application and this property here tonight. So I don't believe I have anything more, and I appreciate you looking at these materials.
Thank you very much.
Any other parties wishing to speak at this particular time? Jerry, that's the last thing.
I'm gonna say, the only thing I did notice, like, the property did look better this time, didn't they this, but the only thing I did know that, John said that most of his trucks are out doing their pickup already, so his garbage trucks right there, where before he did make a statement that, the guys ain't got the road much before 9. So I don't know if he got the trucks out there before the thing, but other than that, I mean, and they said, somebody said wasn't much of a run out there, or didn't have any rain either, been lack of water, but I gotta say, but overall.
Merry Christmas.
Never had that.
I make it up and make the donuts.
That was God calling you guys. Just so you're aware.
That's his wife.
Yeah.
Okay.
But not bad, I said, overall, it did look better than since the first time, but still, it's what is, my opinion, what if, it looks good now, but 2 months down the road, it doesn't, we'll work that dog away. You don't know, so that's only my comment or concern.
I got a question for, and I apologize, I don't remember the lawyer's name. Permitted uses, will the site plan review required? 5.2.3, which is a home occupation meeting the following conditions. One of the conditions is equipment and materials may be stored on the premises if they are screened from the adjoining properties and public streets by natural or artificial materials or kept in an accessory building. Is that correct?
That is correct.
Okay.
If I might add, it says home occupations meeting the following conditions, which means every condition. And if you look at the very first condition, the use is conducted entirely within a primary residential building or in not more than 1,500 square feet of an accessory building. Now, this use is not within, I don't believe there is even a residence on the property. It's definitely not happening in the garage, it's on the full property. So that, even though maybe one criteria makes sense, it would need to follow the rest of them as well.
But I'm asking this more or less for future references. So if this permit application came back before me or the next zoning administrator or this development review board, if the use was conducted entirely within the primary residential building, and Mr. Babson has a permit to build a house on this property, or in not more than 1,500 square feet of an accessory building. So he can have an accessory building there that's 20,000 square feet. And if he's only using 1,450 square feet of that building, or an applicant, let's just be clear on that, they would be totally within 3A. Is that correct?
Oh, well, you're getting into weeds here.
No, I'm not. I mean, let's face it.
No, listen.
No, if there was a resident on an applicant who came before the board, right? And there was a residence, Jared, I'm gonna use you for an example, all right? If Jared came before the board for a home occupation and he had a 20,000 square foot building beside his house, or let's go 3,000 square foot building next to his house, and he was using 1,450 square feet of that building, no matter the size of the building, he would be in compliance on 3A.
No, not under my opinion, because unless it was a use that was actually conducted entirely within the residence. So we're talking about, something that is contained within the residence or the accessory dwelling. If it's storing vehicles for a business that's conducted throughout town or moving in and out all the time, that would not be conducted within the business.
Well, I'll get to that in a minute. That's my next one. So what you're saying is that wouldn't be legitimate because after your highlighted portion, it says entirely within the primary residential building or, that two-letter word's pretty good size, or in not more than 1,500 square feet of an accessory building. Right? Is that what it says? So if he were to come to this board and say, I'm using my accessory building, it's 3,000 square feet, but I'm using 1,450 of it for my business, for my home occupation, it's totally fine as long as he continues to meet criteria.
As long as the use is conducted entirely within either the primary residential building or not more than 1,500 square feet of the accessory building.
Okay.
Bert had his hand up.
Continue.
Just wanted to let everybody know.
The next one's self-explanatory. Signs self-explanatory. Equipment and materials may be stored on the premises, again, may be stored on the premises if they are screened on and if, again, big words, on the premises if they are screened from the adjoining properties and public streets by natural or artificial materials or kept in an accessory building. And at that point, that accessory building doesn't have a square footage listed in our bylaws. Right?
I might add this, the definition of home occupation, the use of the minor portion of a dwelling unit by a resident of that dwelling unit, or the use by a resident of an accessory building on the same lot as such dwelling for an occupation which is customary in residential areas and which does not change the character thereof. Now, you can look at some of the pictures that I showed you around, that are in the packet I sent you, and I'm sure you can see, or I might ask you, does it look like Mr. Batson's property demonstrates the same character as the neighborhood that it's in?
I could argue that point with you all night long at this point, but we're not gonna get into that because there's any number of the same type of situation up and down the street, but that's neither here nor there.
Let's not go there.
Right, exactly. And then the rest of it is basically irrelevant as far as that goes.
So these are the stated bylaws to the town of Pownell, correct?
Correct. This is the right, am I correct? Again, these are the bylaws.
Adopted in 2021, August 12th.
Now, my question would be, as the DRB, how do we go about, and we have the authority, how do we go about granting a variance to the home occupation and these 5 criteria that you pointed out are basically for residential purposes only, in my view?
Well, the answer to that is, so the standard for granting a variance is extremely strict, and it is solely based on physical parameters and when there's no reasonable use. Otherwise, the only recommendation I would make is updating your zoning bylaws to reflect more accurately what it is that you want to add as permitted uses and whatnot in each district. Otherwise, they have to be enforced literally And
For a zoning administrator, DRB can still grant variances pertaining to the appeal of a permit, correct?
the DRB can do that, yes. Whether it will be upheld in a court of law is based on,
The different criteria and the parameters of the situation.
yes.
Correct, okay.
The DRB can do as it pleases, whether or not it will be upheld in a court of law is another question.
Sid?
Good evening. I'm Sid Smithers. I was on the DRB for a number of years and on the planning commission for a number of years. I was on the planning commission that drafted the bylaw, which has now been adopted by the municipal body. And I came tonight because I had read some press coverage and heard some things that had gone here on here. And I became concerned that we were getting off the track. We're getting outside the guardrails of zoning. And we were doing things which I hope we don't go down that road because it leads us astray and it takes us away from the zoning bylaw as it has been proposed. The zoning bylaw, like all zoning bylaws, was adopted to give people in town assurance that where they live will remain the way it is unless they agree that it should change. And the town meeting votes a change in zoning. It's to give an expectation, some call it an investment-backed expectation, that you can wake up the next day and see what you saw the day before. It's not like Houston, where an oil refinery can exist beside a residential subdivision. We have different zoning here, and the zoning is designed to give you the assurance that your surroundings are going to remain the same. And I think we're getting away from that in this particular case, and I don't know why the DRB is running pell-mell toward accommodating this particular applicant at this particular location. I think there is a process. I disagree with my brother who suggests that you can grant a variance. I don't think you can give a variance. I just don't think the jurisdiction is there to give a variance where this is on an appeal and he hasn't asked for a variance. You've proposed the variance. That's not your job. You're supposed to hear the evidence, make a decision. I came tonight because I don't want to see the DRB in the town go south and not comply with its own bylaw.
One point, Sid, I don't think anybody, we discussed the variance. I don't think anybody was proposing a variance. These were words put in our mouth by different individuals in this town. This is a point I'd like to speak to. We had discussed different parameters of this permit. Not once did we discuss variance. We're discussing variance now because we had mentioned of different things that had taken place. I don't think once where we said Mr. Batson could get a variance. We are hearing this permit as run a business on the property as it was stated and presented to this board. We've carried this forth this far because there were concerns from the abutters. There were concerns from the public. And I don't believe at any point in time, short of our brief discussion on what prior boards had done, and Mr. Harsh led us into this one with run an at-home business. And there have been several at-home businesses granted permits. I don't think at any point in time, other than just banter back and forth between the board members and the public, where we had discussed variances. We are still hearing this permit as run a business on the property, which would probably require a variance per se in some aspects to grant this
Yeah,
permit.
because you can't have a business in an R2 zone district.
There are
process.
several at-home businesses that were run in R2 districts.
And that's perfectly legal.
Right, and that's where the precedents, and Paul and I had got into a discussion where precedents had been set. There was a business with several employees and several large trucks on a dirt road that was allowed to exist in this town. And the bylaws hadn't changed drastically from when that one was permitted to when this application came before us. So this is where Mr. Harsh and I got into the banter back and forth.
And Mr. Chairman, with all due respect, I don't think if something has been permitted to exist in an R2 zone district over there, that there is a precedential value that you've got to allow the same thing over here. That's just not the case.
Doesn't R2 carry throughout the town? R2 covers the entire R2 district, not a section of R2.
I understand that, but what you're saying is if you have a trucking business in an R2 zone district, regardless of how it was legalized, if at all, that you have to permit it over here. That's not the case.
I have a question.
Okay.
No, yeah, this, whatever, not my meeting, not my meeting.
Okay. Matt, you finished?
Yes.
Mike, you were gonna speak and then you'll speak.
Yep.
I'd like to ask you a question, Sid. If, because I believe you were on the board that permitted a business in RR2.
Look, man.
And at that point, if you have an RR2 district, and this is your RR2 district right here, and you permit a business in this corner of whatever it is, and over in this corner, another applicant comes before the DRB, as we're going.
Only if the facts are exactly the same.
As we're going, hear me through, this applicant asked for the same permit in the RR2 district. And the DRB denies this permit. Doesn't that open you up for a pretty major legal fight back and forth? Because if I'm the applicant over here in this corner, and I'm gonna say this guy over here got a permit and he's doing the same thing as me 5 years ago or 7 years ago or 3 years ago or whatever it was, why don't I get one? That's my point.
Okay.
So I guess as he brought up a couple of things, Mike had brought up a couple of things, it kind of occurred to me. The board, my understanding is the board job, and if I'm wrong, please inform me, is to protect the bylaws, correct?
We're charged with hearing appeals of a permit that is denied.
Isn't the board's job to enforce the bylaws when somebody, and this isn't for or against John in any way, this is more of it just kind of hit me. Isn't the board's job to enforce
The bylaws per se are to guide the zoning administrator. His job is to abide by the bylaws. Once he denies that permit, the applicant is afforded the opportunity to appeal this permit, bring it in front of the DRB.
Right.
We're charged with hearing all the arguments that need to take place.
Right.
Okay. If per se, Mr. Babson came with this and there were absolutely no problems, none of the abutters had any issues.
Right.
Then in theory, we could grant that permit and allow him
To do.
to do what he wants to
Right,
do.
I understand that part.
And this is the part where we have to allow him his due diligence as well as you, as an abutter and
The neighbors.
neighbors. You need to have your ability to either convey your opposition
The concerns.
or the concern.
Right, so really where I'm going is, if the job is to make sure that the bylaws are followed, and I'll just use John as an example because he's applying, ask for the permit, and it gets denied by you because he doesn't, instead of looking at somebody else has it, it's still by the bylaws, it should be his burden to get a lawyer and fight that decision, not you say yes only because somebody else has been granted that, which was by a different board. Do you know what I'm saying?
It was just a consideration that I, myself, probably, as much as anybody, as a consideration I had taken into account as far as how the town has done things in the past,
But
per se.
we're trying to change that because it was going in
Understandable.
and like I said, this isn't, because I'm actually pretty happy we spoke. I really don't have much of a problem with John's lot. I just,
Yeah.
it just seems like it should be, those are the bylaws, that's how it is. No, you don't meet the criteria,
Then there would be no.
Denied,
There would be no
and then
need,
he
no need
says-
for a DRB then.
well, and then
Right.
you guys say denied because it doesn't fit the bylaws.
Well, if it doesn't fit the bylaws, then
Then it would be that person's job to fight it.
well, he did, he appealed it. And that's where we come in to make a decision whether or not to allow it or not. There are, different instances where a lot of it is just residential, and especially in this town. We don't have a lot of business aspects coming in. If and when the racetrack, and, Beaverwood was one of them. And I'm sure Sid remembers this one very well. When Beaverwood came in, there were a lot of information, a lot of intricacy that needed to be taken into account. And a lot of parties applied for status, and that was a big one. So in this particular case, this is minuscule compared to that, obviously.
Yeah.
But it's part of the same process that we followed through with.
Yeah, I guess I just don't understand how you can say,
Is it how or why we're here?
well, I guess I just don't understand how you can say Dent's got to have this by another board or at another time years ago. So that makes it okay for him, like,
No, I don't think that was,
no, and I'm not, it's just as an example. And I'm only thinking of Dent's because he was mentioned once at one of the other meetings.
We can go through a list.
Right.
I mean, there's several, but
And
they're
everybody's
not.
trying to get the board,
Yeah.
or everybody on the board is trying to get things better, but I just don't understand how it goes. You use an old example to get another,
Because sometimes legal precedents and denial and, these things can be brought against the town. That's the only thing. And if we needed to get legal counsel for that, then probably we would have. So,
well, right now, let's deal with what's in front of Arthur. You were gonna speak and everybody's got in front of them.
That's what I want to do. I want to hear everybody what they've got to say before we get into specifics and reading all of this.
Right.
I want time.
Cindy,
Yeah,
Arthur has the floor.
yep.
Okay. No problem with anybody running a business. The only thing my concern is contamination. Is there a containment law with having disposal containers on the property? You have to change for wells, and you get the fish hatchery. That would be my concern. Is there any, I don't know, structurally, the state or the town, or the county, in the containment area?
I can weigh in on that, Matt. Okay. I can weigh in on that, Arthur, if you'd like.
Sure.
So to the best of my knowledge in the town of Pownell, there's absolutely nothing.
short of a fuel storage facility by state mandate needs to be a double walled structure.
No, that was my thing, but, you know,
Right.
But, so what this process right here could potentially do by being here at the DRB is that is one thing that if the DRB were to grant a permit, and not in just this particular case, and I think Sid will back me up on this 100%. When the DRB grants a permit that's become before them or has the potential to grant a permit, I don't want to say grant because everybody's gonna get twist that and say it's already a done deal, so that's not the case. If they were to potentially grant a permit, those guidelines and regulations that the DRB could place on the applicant, they could say, you have to have a containment area 3 times bigger than the square footage you're using for your storage, type of thing. Those are parameters and guidelines when a situation similar to this or any applicant that comes through, those are things that the DRB can place on the applicant, no matter what the applicant's here for, no matter what they're here for.
right, but what I'm saying is there's no state law requirement or town requirement.
Nothing as far as I know in town. Do you recall anything? I don't think there's anything in the bylaws. Like I said, I've never seen it. I've read them pretty thorough.
I believe that probably falls under state purview. I know, because I know water quality falls under state purview.
A&R.
Yeah, that's what I was
I just
thinking.
wanted to make the point that,
A&R takes that.
once the DRB makes, or, you know, a permit application comes before the DRB, those are things that they can place guidelines and regulations that they have the authority to place on the applicant.
You can put conditions on any.
That's what Mike is talking about.
That's exactly what I'm saying,
So
exactly.
like, if we were gonna make this work, he'd have to do this.
Exactly.
Yes.
That's why we're here,
Yep.
and that's one of the functions, you know, to hear your concerns, hear his proposal, and if there were any way to rectify the two parties and reconcile, and, thank you, sir. Reconcile the differences and put on
Yeah,
parameters,
so
criteria and
You
conditions.
do all this and then everybody else.
And that's one of the reasons we went for the second site visit, so long-winded out through for such a lengthy period of time. As I explained to you, there were concerns over smells.
But the trucks weren't there.
Right.
The dumpsters.
My guys work.
So that was, like I said, that was one of the.
And part of my questioning is not really actually for John, it was for myself, because if I consider
Right. And
finding this
that's,
spot, which is why I was asking.
Certainly.
And I wanna park my 10 trucks and,
certainly.
which is why I was curious.
Is there anything off of Zoom, Hannah? Okay.
Can I just say a couple more points based on this discussion?
I don't know what else, without having our council present. I'm gonna talk from a select board standpoint.
Listen, the
Chair,
whole-
chair of the select board, without having our council present, Matt, I'm not sure, it's your meeting, I'm gonna say my piece. Without having, the town council present, I'm not sure that we should listen to, a counselor, a lawyer trying to persuade a decision without having town council present. If you decided to have a continuance on this, I could certainly speak to the board and we can have town council come in.
with all due respect, I'm here to present evidence and get things onto the record here to make a decision, and town council can review that record, but since they're not present here, it's my duty to present my case as it is to the board, which is,
We've had a lawsuit threatened against us, so my advice from us as a select board is I wouldn't listen to any more from a counselor.
I mean, that's
No,
what the
no.
city is about.
I sort of agree. I think that this is a DRB meeting pertaining to this applicant's application. We're here to hear,
On the process
Everybody.
for the application.
I don't want to feel like we're in court.
Excuse me, let me. Sure. My concern is we're talking about the process. And we're not talking about the application, because the only thing before us is the application. Not, I mean, granted, this is nice to have, okay? This isn't a place to have a grand legal discussion on this. If you've got evidence to pertain to this case, okay,
I appreciate you saying that because you're
China.
bringing things back
Okay.
here where
all right, because
we're looking at.
and I understand where Mike is coming from. If we're turning around and if we have been threatened with a lawsuit,
Rebecca's in the Zoom meeting too, Matt.
okay. If she, but that's my concern.
I completely understand.
And I think what's happening is we're getting way off on talking about in the weeds.
Right.
And we're not talking about the
That's
application.
why I came up to speak one last time.
Okay, good enough.
I appreciate you giving that kind of setting for this. This all comes down to what the permitted uses are in the rural residential 2 district.
Okay,
And the uses of this permit application, in our opinion, clearly don't fit within any of them.
okay.
Under permitted uses where site plan review is required, and also conditional uses, which would be the appropriate time to put conditions on a permit. A permitted use that doesn't require site plan review, that's not where you put conditions on a permit. That is, here's your permit, go about do your thing. There's no need for conditions. And in this case, this application just does not fit within any of the R2 district uses.
Thank you very much.
Hi, everyone. People in there might not know who I am. I'm Rebecca Dragon, and I still serve the town of Pownell as kind of a assistant legal liaison. I am not a lawyer. I always start with that. And I do want to suggest that if you're going to continue listening to from a party that has threatened litigation, especially in the media and in the press, that you would continue the conversation when you can have town council present. That would be prudent. That is the best way to protect the interests of the town. And so that's number one. Number two, I am just want to say from my years now of experience in working with the town and kind of engaging with a lot of these issues and these conversations, I do just want to say one thing that I haven't heard mentioned yet, and it's that it's really great when a property owner comes to the DRB and wants to work with you guys and wants to wants to work with people. And, whether I'm not saying you should grant a permit or not grant a permit, that's not what I'm speaking on at all. But I do want to say that, when they're turned away and not worked with, you also do lose that communication and that relationship to be able to find those compromises on that piece of property, So those are just considerations I would ask you to think about. I may weigh in again with some more public comment, but just as the person who works on all the things legal in Pownell still, I'm just asking you to do not go back and forth regarding with somebody who has, threatened litigation without your town council present. Thank you.
Thank you.
Can I speak up? Thank you very much. I'm Paul Hirsch. I'm here on behalf of the seller of property adjacent to the applicants. And you have pictures before you demonstrating this is not a residential use next door. There's not even a house. Before the board, there's been a lot of talk tonight and a lot of weed cutting and growing. It's very simple. The bylaw is very straightforward. You don't even have, as I said at our April meeting, I'm sorry to say, you do not as a board have the right to grant a variance or even a permit.
Point of order, Matt.
Please hold it.
Point of order. This is the person speaking is the man who is the individual who is publicly threatened litigation against the town.
How did I do that? Would you please?
It was in the banner.
That's great.
I don't want to get into it right now.
I completely deny that.
Your board.
That is absolutely outrageous. You're just trying to shut me up.
All right, can we have
That
just,
is outrageous. I'm going to ignore that because that is completely off the wall. Completely. This gentleman, the attorney representing the applicant, has notified the DRB of what the applicant's, the complainant's rights would be under the law, and you have the right to know that. That if you were to grant a permit, which is not allowed under the town bylaws, their only recourse to stop this is to go to the environmental court, which will throw this out. And he cited various, and in your materials, you have all the legal cases where that is the fact. So frankly, the DRB should never have even heard this, and your zoning administrator should have said, I'm sorry, Mr. Babson, but your proposed use is not allowed in our rural residence district, end of story. But instead of applying ahead of time, what did he do? He started his business on this property. It's loaded with machinery, with trucks, trash containers, with logs, with debris.
Okay,
with
Paul,
an empty
you-
oil tank.
there's no new relevant information.
That is new.
We're going to stop.
And you have the new.
Mr. Batson, is there anything you'd like to
You
add?
can grant this, but you're breaking the law.
My application, because I already have everything I need.
So your permit is withdrawn.
Yes. Everything I need is already there.
So we do not have to formulate a decision. Mr. Babson has withdrawn his permit. We will adjourn. I'll entertain the motion.
Aye.
Make the motion.
Second.
Roll call.
Carl Strohmeyer, aye.
John Bushy, aye.
Cindy Legg, aye.
Owen Dwyer, aye. Cody Gardner, aye. Jim Winchester, aye.
Matt Gardner, aye. Meeting is adjourned.
Okay.
Thank you, everyone, for participating and allowing this process to go forward. I do appreciate it. I think it was handled well.